Okay, welcome everybody. Like Christy said, probably more than half of my work is employee consulting or employee litigation. So some of the things I'm going to go through today are just sort of best practices to either avoid litigation potentially, or to, from an employment perspective, or to put a company in the best position they can be in the event there's litigation or even commission matters. So I'm going to talk about kind of auditing and what attorneys or HR offices can do within each individual company to place them in the best location. So one thing, just as a preview, attorneys are usually advisors from an employment standpoint. They're business partners, and they work closely with the employment law team at various employers, small, large, and multi-international type of companies. So in a recent survey, and it's on the slide here, clients have stated that attorneys who understand how they conduct a business is a significant issue for client satisfaction. One of the things that I frequently ask employers or HR staff is, how often are you doing performance reviews? What do your performance reviews look like? How do you work with your hiring practices, those kinds of things, so that when you are discussing employment issues with them, you are familiar with their general practice and what types of employees they have. Are they business type, standard, office type work versus on a factory floor? And the clients also expect attorneys to be advisors, not just reacting to problems as they are brought to them, making recommendations with regard to employee handbooks when there's issues, or about, hiring process, those types of things. And we'll go over some specifics as time goes on today. And just to note, for all of you attorneys out there, when something goes wrong, a client's first question is, who are our attorneys and why didn't they tell us that we would have this potential issue in the future? So I'm just going to give you a couple of examples that highlight some of the issues with not looking forward, or possibilities that could have been avoided had an employment audit been done sooner. So there was a recent case here in Iowa, most of you probably are familiar with it, where the plaintiff claimed her employment was terminated because of her sexual orientation. This is actually out of the University of Iowa. The plaintiff claimed she was treated differently than employees of another sexual orientation, and that she complained about the issue to her supervisors or to HR staff. She claimed that she was replaced after her termination by a male employee who was paid $70,000 more than she had been paid. The jury, after a several-day trial, awarded her over $1 million in damages for past emotional distress, future emotional distress back pay, that's that $70,000, they'll go back a certain number of years, and attorney's fees, which are usually the most significant part of a potential jury verdict. It takes a long time to get to trial. The testimony from various people that worked with the employee indicated that she had good performance. There were emails and such that complimented her on various performance issues, such that the issues with her employment were not correctly or not adequately, from the jury's standpoint, set forth in her employee file or her personnel file. And I just want to point out that in today's Me Too environment, claims of either discrimination based on sexual orientation or sex or whatever really do make good press, and the press will find these cases. The one I'm talking about here was, of course, a big deal because of who the defendant was, but just for even private employers, significant issues do get before the press, and they will look for these types of cases to report on. What are the employment audit issues that were raised by this case? First of all, does the employer have proper, and I call it EEO, and that's equal employment opportunity policies that protect sexual orientation? Sexual orientation has been a protected characteristic in Iowa for a long time. Iowa also protects gender identity specifically in the statute, and every state has a little bit different. difference between their policies and their statutes as to what is protected. So the other thing that you'd want to look at that could have been raised prior to litigation is, were supervisors and employees trained on these issues? Did the employer have a habit of training employees, both supervisors and employees, on a regular basis, whether that's yearly, bi-yearly, whenever that may be, regarding the EEO policies and how to report concerns? Was there also a process to internally report a claim of discrimination? In the case that we just talked about, the employee claimed that she had complained about differential treatment or harassment in the past. Where did that go? If there is such a complaint, does it get to the right individual in order to investigate it? If the claim was reported, was it investigated, documented, and was there prompt remedial action if there was a finding taken? Was there a policy similar to the first one, a policy prohibiting retaliation against an employee who makes a complaint? From an employment standpoint, this issue of retaliation is the easiest one to prove, because employees frequently feel differently about how they are treated at an employer's office after they have complained about something. Whether that's, hey, I was kept to specific hours, I wasn't allowed to come in early or stay late anymore after I complained, or all of a sudden my employment reviews and my performance evaluations were negative after I complained. Those are relatively easy things for employees to claim. Even if the underlying claim was unfounded, frequently there is a retaliation claim that has some teeth in it. Was there actual retaliation against the employee for reporting the claim? And if so, what was done to rectify the situation? And one thing that can be done ahead of time is you would document specifically that employees were advised not to retaliate, and an HR office frequently should follow up 30 days after a complaint and a finding, whether or not everything is going well with the employee. And those are the things that the audit can look for. Was there follow-up after complaints of litigation or complaints of harassment or discrimination? And finally, was there an internal review of wages to ensure no discrimination in wages based on protected status? As I recall, after the jury verdict and after things were resolved in this University of Iowa case, there was information in the press that there was going to be an internal review at the University of Iowa to make sure that there was no discrimination based in wages based upon how things were done, which could have been done sooner. So, and here's what I said on the next one. So that can be done sooner so that you would have that data to show, how do we decide how various employees are getting paid? Is it a lockstep system? That's very easy, versus it's not a lockstep and we take into account years with the company, performance reviews, and some kind of neutral process to determine how people get either promoted or get pay raises. So could that review have been performed sooner, such that it could have been shown to the jury that that process was followed and there was no discriminatory practice with regard to how an individual gets paid? So there are legal defense, not just from a standpoint of it looks good to the jury, but there are other legal defenses, and we call them various things in employment. But if you have practices and you promptly remediate a complaint of discrimination, there is a defense that can be claimed both in the federal system and in the state of Iowa. Another one that is an example is there was a situation where an employee was terminated after he had returned to work from a brain injury. As I recall, the individual had a real injury. Something like a nail gun, I think at home, a nail had gone into his head and he had a brain injury. And he took several months off of work, but then when he returned to work, he claimed disability discrimination and failure by the employer to accommodate the disability. He received a verdict of $934,000 in favor of the employee, and that is before attorney's fees were determined. The employer in this case did a lot of things right. Number one, they gave the employee time off as a reasonable accommodation for his disability and his brain injury. And then they had, when he did come back to work, they had very specific accommodations. However, not long after the employee returned to work, there were some perceived issues about his performance. And why was this problematic from a jury standpoint is, one, the employer relied on a supervisor statement that he did not believe the employee could perform the job duties, but that supervisor had never actually observed the employee doing the job duties at all. There was another more direct supervisor who had seen the employee correctly performing the job duties. So there was this very vague statement that was made, and that was the basis of the termination. But another supervisor said, no, I saw him do X, Y, and Z correctly. And as I recall, he was some kind of water treatment installer or meter reader, something like that, for a public employer. They also went out both before he originally returned to work and before they terminated him, and this is the right thing to do, they went and got a medical opinion. So the first medical opinion before he came back to work said, we think he can perform the essential functions of the job. But a few months later, after the supervisor reported he didn't think he could perform the job, they sent him back for the medical opinion. That medical provider did not, as I recall, actually have the employee come in on that second instance. And based upon the inaccurate information from that supervisor, the medical provider gave an opinion at the time of termination that he was not able to perform the essential functions of the job. But when they were asked at trial about that opinion, they really hedged that opinion, and they stated that opinion was based almost entirely on the information that was provided by the employer that may not have been accurate. So what are the issues raised by this relatively recent case? Is you need to have, number one, you would want to look for a clear process for accommodating employees. And you would also want to look at documentation of accommodations offered and or rejected. The law, this is not meant to give you a full overview of what the law requires with regard to accommodations, but you are required to reasonably accommodate a disability. You don't have to give the individual what they want necessarily, but you have to consider that and decide if it's reasonable or not. So each thing that the employee asks for, either orally or in writing, you keep track of that and you decide whether or not it's appropriate or not appropriate, and you tell the employee yes or no and why. You should also pay careful attention to the information from an employee's medical providers. Are there reviews and medical opinions asked? And if so, is accurate information provided to them? Make sure that the supervisors are relying on and have correct and up-to-date information. This is kind of the same thing, documenting the interactive process, and then follow up with the employee to make sure that the accommodations in place are effective. Similar to what I said before, is go back to the employee 2 weeks, a month, 6 months later, hey, you know, we gave you this new computer screen because of your eye issue. Is that helping you? And if the employee says, yeah, everything's great, then you do a simple documentation to the file so you have that. If the employee says there's problems, then you say, what else can I do for you? So what policies are critical as part of an audit that should show that you have these are required documents? What documents must there be at an employer? Federal and state law require various certain policies. That would be an FMLA policy if you have 50 or more employees. There aren't a lot of other policies per se that are required by regulations, but they are encouraged or looked upon negatively if they don't exist, and that would be an EEO policy. So the EEOC specifically has stated that if you don't have a policy, they're going to assume that you don't recognize discrimination and provide recourse for employees. So you need to, almost every employer that we deal with, have either a handbook or a separate policy that is, you know, the employer prohibits discrimination or harassment based upon a protected characteristic, and then provide a policy about reporting concerns regarding those things. The EEOC also wants contemporaneous documentation to show that an investigation was performed, and the policies need to be easy to follow. So I have a checklist here that you can go through to determine whether or not there are appropriate policies or appropriate issues that are addressed within each employer. Now, I do want to point out that there is never going to be an employer, no matter how sophisticated, that are 100% compliant with all of the issues. And it is helpful sometimes, not always, but it's helpful to conduct the audit under an attorney-client privilege so that you can be telling the employer exactly what's deficient within their policies or within the checklist, and that is not then discoverable should there be litigation or otherwise. There's also, and I did not attach it, but you can find it quite easily through Google, the EEOC has produced a self-audit checklist that's even more expansive regarding the EEOC's opinions. So, and I'm not sure that you can see this. I have to move it to a different screen. So this is the checklist, and some of these things we've already talked about. I'm going to go through them quickly. So now, first, I already talked about attorney-client privilege. In every audit, you should look at the employee application to make sure there are no improper questions. You should not necessarily ask about whether you've been arrested or charged with the crime. You can look at convictions. In this, I know this is an Iowa seminar, however, in the state of Illinois, because I work on the border, the employers in Illinois cannot ask about convictions. There is a law specific to that in Illinois. In addition, the EEOC disfavors those types of questions. They think they're discriminatorily keep out minorities. So that's something to look at. And there's other things about disabilities and such that you will not want to have in your applications. Offer letters should also be reviewed to the extent your employer sends offer letters. You need to make sure that they do not create a contractual promise. There should be at-will language in any offer letter so that you could terminate. It's very frequent that offer letters, for example, will say, hey, we offer you this job for $50,000 a year starting on March 1st. Well, that could be interpreted as that's a year contract. You're now giving them $50,000 a year, so we assume that that's for a year, such that you cannot terminate them before that because there's a promise in a contract. So you need to make sure that you can have language in there that indicates you would terminate for any time at any reason. You want to look at if your employer does pre-employment testing with regard to their ability to do the job, or drug testing in compliance with Iowa law. And just for those of you that may not be familiar, this is probably the drug testing statute in Iowa is probably the most complicated statute that exists that I know of. It's, I don't know, 6, 8 pages, maybe 10 pages, single spaced in the code book with regard to what you can or cannot do. It's almost impossible to comply completely with even that statute, so you need to have substantial compliance. Various employers will do background checks. The Fair Credit Reporting Act requires various disclosures be made at the time of the background check, and otherwise you need to make sure that those are followed. If an employer uses interviews and has a specific way to do those interviews, you need to make sure that appropriate questions are being asked. Individuals shouldn't be asked about their marital status, whether they have a disability, whether they've had a past work comp claim, those types of things. If an employer has employee agreements, you'll want to make sure that you consider whether it has an adequate non-competition clause or a confidentiality clause to protect proprietary information, and that there's adequate consideration. Job descriptions is a big deal. You need to make sure that those are accurate, up to date, that they include the essential functions. Case law came in, I can't remember which circuit, but there was a circuit that just came down late last week that indicated that working overtime may not be an essential function if it was not in the job description. Courts will absolutely look at the job descriptions to determine whether or not it's an essential function or not. And if it's not in the job description, it's likely not essential. I-9 documentation. Any agency, usually, specifically the Department of Labor, for example, if they come in to look at anything at your employer, they will look at the I-9s for compliance. The other thing is another big problem that you'll see in audits is whether or not employees are properly classified as exempt or non-exempt. A year or two ago, we had regulations that were changing what the wage had to be in order to be exempt. Those have now, they're on moratorium. They may or may not go through with this current administration. Lots of employers looked at classifications back in the past year to two, but not everybody did. And you need to look at whether or not employees are properly classified. Employee handbook, you want to make sure an employer has one or at least has policies, and that it's up to date and it's circulated to all employees with a signed acknowledgement. In today's electronic world, electronic signatures are fine. Is there a policy in place to report discrimination and harassment? We already talked about that. Is there training on non-discrimination, harassment, retaliation, and accommodation? We recommend training on a relatively frequent basis for your supervisors, and less frequently, but at least provide that to all employees so that they know how to report concerns. The other thing, for those that do drug testing, you're going to make sure that supervisors have training on that as well, because there are requirements in the statute that regarding drug testing. Most of these we've talked about. Personnel records, you're going to want to look at as part of an audit to make sure that the proper information is in there, that confidential medical information is kept separately. You want to check postings. All employers are usually pretty good with this, that the EEO postings are up to date on the boards near where employees meet. Review the wages and the FLSA for potential violations. Any non-exempt employee, which is a large portion of any staff, must receive overtime for any work over 40 hours, whether they're on commission, whether they're even salaried, it doesn't matter. You need to pay them overtime with regard to any work over 40 hours. That there's some kind of system in place for managing FMLA leave, short-term disability, long-term disability, managing employees with disability, religious accommodations, and performance reviews. This is a big one. You're going to want to make sure that your employers have a process in place, at least with regard to performance reviews, whether it's conducted, how frequently it's conducted. Are there improper references in the review, making sure that supervisors, for example, and I think I talk about this later on the slideshow as well, that they do not mention when they're providing constructive criticism that, hey, the employee is doing great when they're actually here, but the leave that they had is appropriate leave under FMLA, work comp leave, or potentially disability accommodation leave. You only should consider when they're actually at work and how they're performing when it's appropriate leave. You want to look at how feedback is provided, making sure that it's appropriate, and that there's adequate documentation of performance issues. When I talk to employers about this most frequently, I tell them, you know, if a supervisor supervises 20 employees, I should be able to pull out the 20 last performance reviews and look at them and determine who are my average employees and who are my star performers and who are the ones that have a few issues. They may not be to the level of termination types of issues, but they should be enough so that somebody independently looking at those reviews knows where the problem employees are. Is there also a process for HR to be involved if there's termination? You want to make sure that there's a process with regard to either termination or when an individual resigns or doesn't show up for work, making sure that wages and vacation are paid at the regular standpoint. That's the other thing you need to look at for policies. The law provides that unless the handbook or policy of the employer provides specifically otherwise, an employee is earning vacation while they're there, and that needs to be paid out when they no longer work there. If a policy provides that an employer will not pay for unused vacation, that's okay. You just need to make sure that's spelled out and provided to employees. Document retention, there are various requirements with regard to document retention. And are there proper steps taken upon receipt of a claim or lawsuit? Many employers have insurers, and so if they get a claim or a lawsuit, you should notify that insurance company so that they can help defend you, put a legal hold so that documents are not destroyed, conduct an investigation, and then have a defense. So that's kind of a summary of what should be audited. And I have some things that are a little bit more specific. So why are handbooks so important? I often will get and receive employee handbooks from employers that they've downloaded from the internet, and obviously one size does not fit all. Every state has a different requirement with regard to what is protected, and some states have other things that must be included, or other laws. There's states that have some victim assistance. Some states have, election day, you have to give various time off. In Iowa, we're required to give Veterans Day off, for example. Those are the things that you're going to be looking at in the policies and in the handbook to make sure that there's compliance with all of those laws. So what mistakes can be made? So there was an example where an Iowa business included policies based on California law in their handbook, and they had to give all of those benefits then to those employees as set forth in the handbook because that was the company policy. And basically the court or someone interpreted this, determined like, hey, you promised them, they accepted it based upon the handbook that you provided them, therefore you need to provide those benefits to them. So you can, of course, be more generous than the law requires. Just make sure that an employer is thoughtful about that. I see this a lot. An employer with only 10 employees includes an FMLA policy, and that gives all employees their FMLA rights, and you must give them 12 weeks off with or without pay for a serious health condition. So the other thing is separation pay. It's not infrequent for me to see an employer's policy that talks about after you've worked here for 3 years, upon termination, you'll be provided 1 week of pay for each year of service. It doesn't talk about, that's upon retirement, for example, or it's just reads as if it's a separation pay for all employees. I've seen other employer policies. It's of course not required. If that's what your employer wants to do, that's fine. You just need to point that out as part of your audit process or your review process to make sure that they're aware it's not required and now they've obligated themselves to do so. Other policies will say, we're going to give 2 weeks notice upon, prior to terminating your employment. Well, that's essentially giving them a contract, and it's not advised to do so. You can do that. It's basically a severance policy. Employers just need to be aware of that. Employers also need to make sure that they actually follow the policies in the handbook. For example, some employers will have progressive discipline policies, and those progressive discipline policies need to be followed if it's in the handbook. So if you have a first step, second step, third step, fourth step before termination, then for every type of performance issue, you need to follow that. So they were late day one, you gave them a first step. And then let's say the next week, then they were rude to their supervisor. Then that's the second step, whatever it may be. I would advise progressive discipline is fine. However, there has to be, my recommendation would be to have a bypass for egregious type of behavior. And employers do that differently. Some of them will specifically outline those types of things that will lead to progressive discipline, and others will just say we have the right to, we have the right to bypass any steps based upon the behavior. So it just sort of depends. You also need to make sure in the handbook that there is a process to for internal grievances, mostly on discrimination and harassment type of issues, but certainly you want to give the employee a bypass, whether it's based upon a protected characteristic like a disability or their age or because they're a woman, whatever it may be. If they're just not getting along with their supervisor, there should be at least a process for them to bypass their supervisor to talk about those performance concerns and issues that they're having. These are the key provisions. Most of these we've talked about to include in handbooks, and they don't have to be written, printed out handbooks anymore. Some of them can just be on a computer. It just depends on what type of employer. You're going to want to have an employment at will policy for the same reason you want to have that language in any offer letter that you provided, because you don't want to create a contract that you're required to employ individuals for a certain period of time. Same thing with regard to it's not a contract. I've talked to you a lot about worst case with regard to employment policies and them creating some kind of obligation. I always put in my employee handbooks and in the policies that nothing in this policy or handbook is intended to create a contract between the employer and the employee. You're going to for sure want to have an EEO policy listing all the protected characteristics, and then having a catch-all or any other characteristic protected by law, because those do change from time to time. You'll want to have a prohibition against discrimination, harassment, and retaliation. You need to have how does an employee report the complaints? And probably have a bypass for them as well, because sometimes the person that they're complaining about is the individual to make the report to, so you need to have a bypass procedure as well. You want to have a policy that indicates that the employer will accommodate individuals with disabilities, individuals with religious needs. You need to have a drug testing policy if you are testing. If you don't test, that's fine. I frequently will get calls from employers about somebody coming to work drunk, and what do we do about it? Well, a lot of them frequently will send them out for testing before they even call us. My usual recommendation is employers, test if you need to test. When you can't tell for sure that they have alcohol in their breath and they're slurring their words and everything else. I mean, if they're drunk at work, you don't have to test them. It's obvious. Maybe make 2 people observe and make the notes of what the concerns were, and you can take action without testing. FMLA policies need to be in the handbook if there's more than 50 employees. You need to have compliance with regard to military service obligations, internal grievance process, and access to personnel files. Other things to include that will help in the defense of claims or make things more clear for an individual. So for example, if an employee is terminated for violating a policy, it's much more defensible if there's a written policy in the handbook or somewhere else with regard to those examples. So that would be the progressive discipline policy, for example. You'd want to have that in there. The attendance requirements that you're required to be at work for your scheduled hours. Your failure to be there at those scheduled hours are going to result in disciplinary action. It's quite simple. Other employers will have a step or a point system with regard to attendance. That should be in a policy if you have one. Workplace conduct, at least a general issue or general statement regarding appropriate workplace conduct should be made. You don't have to. I've seen it. It doesn't have to be there. Some employers will have a list, 2-page list of all the things that can lead to disciplinary action. It could be insubordination, salty language. It could be yelling at individuals, lots of different things, attendance, being late, sloppy work, whatever that may be. You want to have those in the handbook if applicable. Discipline, how you're going to discipline individuals. You should have something in there about disciplinary action in your handbook. Something about violence in the workplace is not acceptable. In Illinois, for example, there's a specific statute with regard to violence in the workplace and providing accommodations for individuals that have been subjected to violence outside of the workplace. Most employers, depending on how big and what type of business they're going to have, you're going to want an ethics or a conflicts of interest policy or a requirement for reporting types of potential conflicts of interest. In this day and age, individuals will date or develop relationships within the office. You want to make sure that those individuals report those so that you can bypass the create a different reporting structure to the extent they report to one another to prevent problems down the road. You want to have a policy for handling confidential employer information and employee information. And you're going to want to have a policy about privacy and right to access. And that's mainly about computers. The workplace computer is the workplace computer. Employees should not have, I advise employers to have a policy that says, employees do not have an expectation of privacy with regard to the use of the computer. We all know that individuals use the computer for private, personal matters, and that's okay. But if they're using it inappropriately, you want to be able to access that to see what they're using it for. In addition, after termination, you want to be able to access that employee's computer. A lot of times you can find evidence of other things within that computer. So you need to have a policy that allows you to do so. I think you have that right anyway, but it's much clearer if you've indicated so in a policy. What are some red flag employer policies that you should watch for? You do not want to have a policy, nor do you want to tell an employee that they have to be 100% before they can return to work. Under the ADA and the amendments to the ADA, you need to reasonably accommodate an employee. If the thing that they can't do is not an essential function of the job, you need to reasonably accommodate that. So, for example, it's not infrequent that somebody that is on a factory floor can work on the factory floor. They just need to have a stool available to them to sit down for a minute every 30 minutes. And that's probably okay. That's probably a reasonable accommodation. They're not 100%. They have to get off their feet for a certain period of time every 30 minutes. Employers not infrequently will say, you can't return to work until I get notification from your medical provider that you're 100%. And that's not the law. And the EEOC, I've seen them present at presentations, and they say it directly, is if you have a policy or that is what is said, they will make a finding of probable cause of discrimination. So that's a really huge red flag. If you give leave as an accommodation under the ADA or work comp leave or FMLA leave, you cannot count that time off when disciplining an employee for attendance. All of that leave is protected leave. So you want to make sure that there are policies in place to make sure that what type of leave an employee is taking is protected, and you exclude that from counting that leave to determine whether or not a person has met the attendance issues for disciplinary action. You also should not have automatic cutoff dates. And these are very similar to the ones up above. So it's not unusual for there to be an employer policy that says we have short-term disability for 30 days. If you're unable to return to work after 30 days, you're going to be terminated or considered a voluntary quit. That is a problem for the EEOC, because if they're out on disability, either short-term or long-term, whatever that may be, let's say they're out for 30 days because they had knee surgery. You need to, after those 30 days, that's okay that your policy says we're only going to pay you under the STD policy for 30 days. That's fine. But the automatic termination is a problem. You need to make sure that those policies and the consideration from HR staff is after those 30 days that you're having that interactive process with the employee to determine whether or not they're going to be able to return to work with or without a reasonable accommodation. What if the employee, for example, had a doctor's visit like one day later after those 30 days expired? It's probably a reasonable accommodation to allow them to have that one day. What if it's 6 months later? maybe not. But those are those things that you have to consider, and it depends on each employer. So after any leave, FMLA, LTD, or STD, if your employer has them, you need to determine whether or not they can return to work and engage in that interactive process. Job descriptions. This is hugely important, and it's really important to determine when there's a disability, and as I talked about at the very beginning, with regard to whether or not the individual is actually performing the job correctly and what was required of the job. So the essential functions of the job must be clearly stated. You should look at these, or your employers should have a process of looking at these on a regular basis, because jobs change from time to time. They morph into when somebody else starts working, or different supervisors, whatever it may be. And you, as the employer, are allowed to determine what are the essential functions. You do not have to change those essential functions. If they have to be able to do data entry on a computer for 40 hours a week, 8 hours a day, that's fine. You can determine that to be an essential function. Is there a way you can accommodate that by giving larger breaks or whatever? Those are the things you have to think about. The non-essential functions, however, can be reassigned to other employees. So you have to be very careful. It's also really important for work comp claims to determine when they can return to work, whether they've met maximal medical improvement, and whether or not they're going to have a permanent disability. So those job descriptions are extremely important, and it's not infrequent, depending on the type of job, that not only what functions are essential, whatever those may be, but also what other things are required. Are you required to sit for a certain period of time? Are you required to stand? Are you required to lift? Are you required to stoop, bend, communicate appropriately with others? There's lots of things that should be in those job descriptions, not just what their daily job is, but what functions must they be able to do. Do they have to drive if they're a driver? Or if they do sales, if they do outside sales, that they need to be required to drive up to 80% of the time. Those are the things you want to have on there. It's obvious that most employers do have lots of outdated descriptions, or they have perfect job descriptions, but they do not. You need to have a process for that employer to look at those job descriptions to make sure that they accurately describe those jobs. Supervisor training. It used to be that training was a gold star. The EEOC, if they came in and they were doing an investigation of a complaint and they saw that they had an employer that had some regular training, they would be like, wow, you guys are ahead of the curve. Now it is absolutely expected by the EEOC and some of the individual, the lower level commissions. The supervisors are on the front line, and their actions directly create liability for the company, kind of on a strict liability basis. They bind the company to what was said and what wasn't said. So they do need to be trained. What needs to be trained? We talked about these before. Not discriminating. What does the policy say? Prohibiting harassment, that there's not going to be retaliation. What are the responsibilities to employees with disabilities? What should you say and not say? Responsibilities to employees with religious accommodation issues, including dress and grooming practices, FMLA leave issues, and the proper way to document performance concerns. Now, I'm not saying that every supervisor needs to be fully versed in everything regarding these, but they need to know enough that if an employee comes to them and talks to them about, their need for knee surgery, that they can say, okay, are you going to need leave? You need to talk to whoever it is in the company that deals with that to determine what leave is going to be required. So other employees, I do think it's a good idea to train all employees on the EEO policy, discrimination, harassment, and at-will employment. That way employees know where to go with concerns. It also can provide a defense. Well, for sure, a supervisor training provides defenses. But if you have trained employees on how to report concerns and behavior and those kinds of things, say you trained them 5 years in a row on all of this, and all of a sudden an employee comes to you in 2018 and says, this has been going on since 2010, you legitimately can ask the question, why didn't you report this then? We've trained you to do so and you didn't do that. There are some defenses to those claims, those old claims, because they failed to report that. Performance reviews. Performance documentation is obviously a huge key to prevailing in employment claims. For the same reason that we talked about with that individual that was terminated, if an employer does not have a routine performance review or a process to document and act upon poor performance, a court, a jury, the EEOC, whoever it may be, is going to assume that whatever you say about their performance is just simply not true because you don't have the documentation. And it's not just the court or the EEOC. A jury is most jurors have been employed and are familiar with the employment performance review process. So if it's not in that performance review, or at least in documentation that was discussed with the employee, they're going to assume that everything was fine. It is extremely common when I get a call from an employer that, hey, I want to terminate Johnny. He's the worst employee I've ever had. We're ready to terminate. And I say, okay, what documentation do you have? Because of course, Johnny has a disability or Johnny has a past work comp claim. I'm going to say, what are your performance concerns and where's your documentation? And they send those to me and I look at those performance reviews and they're glowing. They either look great or they are at least neutral at best. So you need to make sure that supervisors in your HR department are giving accurate, factual, non-emotional performance reviews. So if an employee is not performing appropriately, one way to do that, because some employers aren't good about doing, a yearly performance evaluation, but they know it when they see it, when someone's not performing, then put together a performance improvement plan and document that and provide it to the employee. Tell them what you expect them to improve and, follow up on it in 30 days and 90 days or 6 months, depending on what the concerns are. The other thing you should make sure is that, and we talked about this earlier, you should not talk about any protected characteristics on their performance reviews. You shouldn't comment on absences when somebody has FMLA leave or work comp leave. You should not include reference to protective activity in performance documents. You shouldn't say, hey, Johnny came to me and complained about X, Y, and Z related to his knee surgery. So that is for separate documentation, not for the performance reviews. Employee classification. We talked about this briefly. There's full-time, part-time, and independent contractor status. And when you do an employment audit, you should look at what does your employer have, when are benefits provided, and that type of thing. There are lots of tests out there for independent contractors. There is a test specifically that, for example, the IRS will use. All of the tests are a little bit different depending on which agency you're concerned about. But generally, it's if it looks like an employee, acts like an employee, walks like an employee, it is an employee. Just because, I have had employers, for example, that individuals will retire and they leave for several months, and then all of a sudden there's a project and the employer will come to them and say, hey, can you come just work on this one project? And if it's one project and the individual is coming to and from when they want, they're working from home some, they're only working on this, they don't have to report and be there from 8 to 5 every day, whatever it may be, maybe they're independent contractors, But those situations frequently morph into not just that project, but they keep working there beyond. And they really report to work between 8 and 5 every day, and they have a supervisor type of person that assigns their work, and they do everything with regard to what every other employee does. They're probably an employee. And for the purposes of IRS, for purposes of the EEOC, they're probably going to be deemed to be an employee. So you want to look at that situation. There's other situations where they're not. But obviously under also the Affordable Care Act, being full-time or part-time is extremely important as to whether or not you have to offer benefits to the individual. I believe that the threshold is 30 hours a week, and they must be offered health care from the employer standpoint. So you need to look at that during your audit. Your FLSA classifications and overtime liability, we talked about this briefly before. Exempt, are they exempt or are they non-exempt? You have to pay all non-exempt employees overtime wages for hours worked in excess of 40 hours a week. You as an employer define that week. Is it Sunday to Saturday? Is it Tuesday to the following Monday? It doesn't matter what it is. It needs to be a consistent week all the time. And you cannot, as a private employer, give comp time in lieu of providing overtime for those 40 hours a week. You would be surprised when you did an audit or when talking with your employers how many of them think that comp time is okay. And if the Department of Labor, if you get one complaint from an employee, the Department of Labor will come in and do a full audit and determine what your liability is, and they will go back 2 years or 3 years to determine the overtime liability and potentially double that. There's a liquidated damages clause in the statute, plus attorney's fees if there's an individual that brings a claim privately. So another thing to look at is managing employees with disabilities. Disability claims obviously continue to rise. It's a big thing for employers. It's probably one of the most frequent questions that I get on a relatively frequent basis. And the employers do need to be proactive. You should include the employee in the discussion and the interactive process and document that. Ask for information from the employee's medical providers. If you're in an interactive process and the employee says, well, I need, for example, I've had this one, I can't drive at night, which works okay in the summertime for that employer because it's light out from 6 o'clock in the morning until 9 o'clock or past at night. But come December, when it's dark at 4:30 or 5 o'clock and the employee's hours are 8 o'clock to 5, and they say, well, I have to have reduced hours. Well, maybe you do, maybe you don't. So maybe you ask for documentation from the medical provider. Is that then something that you can accommodate on a part-time basis only in those winter months? Or is it something that you can't? It kind of depends on that individual's jobs. Do they have a teaching schedule, for example? Do they teach at night? Or do they work in a factory job, but where you can't just replace somebody partway through the day on that line? Those are the things you have to look at as to whether or not it's an appropriate accommodation or not. You want to make sure that your supervisors are relying on up-to-date information from the employee and the medical provider. You need to document that interactive process and keep the documentation of every accommodation that you give to the employee, along with the follow-up to see if it's working. We talked about this before. You do not need to give the specific accommodation that they ask for. You only need to provide an effective and reasonable accommodation. The other thing that employers you want to look at when you're asking your employers about their policies is, do they have a separate policy if the injury happened at work? The reality is it doesn't matter. If they have a disability, they have a disability, and you need to accommodate them. The EEOC gets really upset when they come in and see there's these whole bunch of workers that get light duty work because they have a work comp claim, but they don't do that same analysis if it's somebody without a work comp claim. ADA leave or disability leave can run concurrently with FMLA, so you want to make sure their leave policies and their handbooks say so. Is there a process of what happens when an employee is terminated? You want to make sure that HR is involved so that there's a consistent process in place. You want to analyze anytime a supervisor comes to HR, you're going to want to make sure that HR is involved and doesn't just react, but they ask the correct questions about why, what happened. Because what if that supervisor is just tired of the employee not showing up, but they're not showing up because they have intermittent FMLA leave? That's protected. You cannot terminate. What is the processing of termination required, and what documents do you need to provide? Almost all employers will need to give COBRA nowadays. There's a few that don't, but COBRA is very much required. So after termination, you have so many days, and many of the employers outsource this, but if they don't outsource, you're going to have to check their process to make sure that COBRA is offered to all individuals who are terminated by the employer, or if they quit on their own. You need to make sure that all wages and vacation pay are paid at the next regular payroll period. That has to happen. Sometimes if it's a commission salesman, there's some exceptions as to how you do that evening out, but you do need to make sure that vacation pay and the wages are paid. I do recommend an exit interview and check with that employee about what do they like about the job, what didn't they like about the job, any issues with their supervisor, why are they leaving, those types of things. The EEOC self-audit checklist also includes the following questions. Were adequate and documented warnings given to employees discharged for poor performance, excessive absenteeism, or other violations of the company's work rules or personnel policies? So the self-audit would be, once we make a decision to terminate, does somebody go back and look at all of those previous warnings to make sure that they're adequate and documented? So for example, was the last warning given to the employee 10 years ago? Even if we're on the 4th step, is that going to be reasonable? Because you need to make sure that you're not doing it on a discriminatory basis, that somebody in a protected characteristic didn't get that exception, but another person did. Prior to terminating employees, are managers and supervisors required to follow consistent procedures to ensure there has been an investigation of the alleged violation of the company's work rules? So you don't want it just to be off the cuff that a supervisor makes that decision, but that there is a process to make sure that a thorough decision has been made about a violation. I think that's it. I don't see any questions. So if anybody has any questions, feel free to reach out to me.